so much.
Ms. Sullivan, I'd like to make a motion, please.
What is the nature of your motion, Dr. Lawrence?
I'm going to make the motion right now.
Okay.
So I don't make this motion lightly. Please do not construe this as being something that I haven't pondered. I just think we've gone too far down this road.
Mm-hmm.
So I'd like to make a motion to remove Ms. Sullivan as board president. I'm going to read my resolution and pass it out. Be it resolved that Judy Sullivan should be removed as president of the Ramapo Indian Hills Board of Education for the following non-exhaustive list, which includes but is not limited to public admonishment and evaluation of superintendent and administration, use of board letterhead for public statement without receiving board approval and without questions being posed to initiate a response, silencing board members during discussion in violation of Robert's rules, and excessively seeking legal advice without board discussion, resulting in an impending $500,000 yearly legal bill.
Second.
So your motion is not recognized because under Robert's rules, I'm entitled to a trial and a hearing, and so the motion's not recognized.
That is not the
That is
case.
not
Our
true.
policy does not state that.
That is not true. This is not a court of law.
Can I have a motion to open for public comment?
No.
Excuse me. Point of order. You are not correct in your assessment. Our policy allows for us to remove you. He has stated the motion. It has a second. We must hold a vote. If you want to discuss it, we can discuss it. But you are not entitled to any type of trial. Our policy states that we can remove you.
So the motion's not recognized?
I don't think you have that authority.
It's under Robert's rules.
Where?
I can call a recess and research it.
There's a motion on the table. When there's a motion on the table, we need to vote.
It's not recognized.
You
Sorry.
don't have that authority according to our policy, and I'd like Ms. Zeno to weigh in on this, please.
Ms. Zeno is not the parliamentarian for the meeting, and I can call a recess if
You
want to do the
cannot
research.
make that assessment. This is against you, okay? You do not have the authority to assess that. It needs to go to another party.
Can I have a motion to open for public comment?
There's
Point
a
of order,
motion
there
on
is a
the
motion
table.
on the table that needs to be addressed. You must address the motion. That is according to Robert's rules.
It says in the motion, in Robert's rules, that I'm entitled to a hearing, I'm entitled to have the charges brought back to me, I'm entitled to have a process that can be heard. You can't just do it.
This is
on
not a
one hand.
trial.
You can do that
This
after.
is a motion, a discussion, and a vote.
You can file a grievance with the county superintendent or the state superintendent. You're more than welcome to do that. You can ask for emergent relief. As of right now, there's a motion on the table. We must take a vote.
I'm not recognized.
You don't have the authority to do that. This is against you. Someone else must make the decision.
Sorry, but what is the Robert's rules section that you rely upon for removing the president or any officer? What's the section?
Our policy
Our
allows
policy.
for you to be, board president to be removed.
I'm sorry, I know we went through this a couple of years ago when you tried to threaten to remove another board president, and there is a policy, there's a hearing that I'm entitled to.
That's not true.
That's not true.
Yes, it is.
There's a motion on the table.
That's been seconded.
Ms. Zeno, can you please?
A president or vice president. I'm going to read the policy.
I'm going to call for a recess.
Board policy, there's a
Recess.
motion on the
I
table.
have to
Ms.
research
Zeno,
this. I have to research this under Robert's rules.
there is a motion on the table.
Sorry.
0152 board officers. A president or vice president who refuses to perform a duty imposed upon him or her by law may be removed by a majority vote of the board members present and constituting a quorum. In the event the office of president or vice president shall become vacant, the board shall, within 30 days thereafter, fill the vacancy for the unexpired term. It is the same thing that is put in state statute. You do not have the authority to rule on yourself. There is a motion on the table. I'd like to call a vote.
I'm sorry, the motion's not recognized.
You
because
don't have a right
have
to
that
do
right.
that. It's against you, Ms. Sullivan. You cannot rule on something against yourself.
I'm sorry, so you walked in this motion without telling anybody.
You walked in 6 motions on January 5th without telling anyone.
Remove a board
Why are you preventing Ms. Zeno from giving us her opinion?
Because I'm the parliamentarian.
But this is about you.
This is about you. You cannot rule on yourself.
Rule that says that I'm entitled to a hearing.
After the vote.
No.
Yes.
Before the vote. You can't remove the officer and then have a vote afterwards.
This is
insane.
not a trial. It's
It
a
says in
motion that's
Robert's
been
rules.
seconded.
So I'm going to call an adjournment, recess right now, so I have time to research this.
You can't do that.
What
There's a
you've done is
motion on the
completely
table.
out of order. Completely out of order.
I'm going to research this.
Completely out of order. You are completely out of order.
This is
I think,
emblematic of
excuse me, I think to take a recess, we have to take a vote.
Yeah, you can't
We
just
have to vote to take a
We have to
recess.
vote for a recess.
No, I
Yep.
can call a recess.
No, you can't.
Gotta vote
There's a motion on the table. You
It's
can't,
not a priming motion.
if you walk away, that means you're walking away. We'll continue the vote.
Maybe if we had legal counsel here, we could get an answer to this
You
question.
know what? We'll call legal counsel. How's that?
Dr. Dionisio, would you mind asking the students if they might want to go home for?
You have to direct your questions to me. Could you just give me a few minutes to look up Robert's rules to advise the board about the process?
We already looked this up. We have policy. Yes, we have policy. I just read the policy. You do not have the right, Robert's rules does not trump our policy. Our board bylaws state that we take Robert's rules in the procedure of the meeting, but our policy, as far as board officers, trumps that. A motion is on the table. You must call a vote.
It doesn't trump it. I'm sorry. You just give me a few minutes to find the section. And we are entitled to have discussion on this too. You don't have to leave over that.
No, I'm saying they should be asked if they want to leave, they shouldn't be told to leave.
Yeah.
How do you know they didn't want to leave? You don't know what he said to them. You don't know what he said to them.
I'm saying everyone was asking to think about everything, gotcha. No, you do.
There's a motion on the table. Aren't we going to vote?
No.
Can we
because
call a vote?
Have discussion. We can have discussion.
So let's
There's
have
some-
discussion.
I'm looking up the rule because you just totally ambushed me here.
I thought you said that it wasn't recognized, so now we can have discussion?
Oh, now we can,
I'm
she just
trying
said
not
we
to
can have
discuss it.
discussion.
I would like for Ms. Zeno to opine.
I'm sorry, she's not the parliamentarian, and it's really
She's
unfair.
the BA.
This is something
So
that should
again, you're
go-
muzzling people.
This should go before board council. I'm gonna call a recess. This is a pretty serious thing to remove.
There's a
the board.
motion on the
There's
table.
There's
You
a motion.
can't call
You
a recess.
can't call a recess without first finishing the motion.
Well, we can have discussion on the motion if it's recognized, but I need to actually research this to make sure we're doing it the right way.
Why don't we ask Ms. Zeno to give us her opinion?
I'm gonna call board council. I think we need to get advice on this. I know she's in a meeting, so let me try to text her if she can break out for a moment.
I just want to read 62.3. The chair must recognize any member who seeks the floor while entitled to it. Aaron made a motion. You must recognize the motion. The motion was seconded. The chair cannot hurry through the proceedings so quickly as to deprive the member of their rights to debate and to introduce secondary motions. I believe that that's what you're doing right now,
This
Miss.
is a very serious motion.
Well,
and
we
I-
know it's very
and I wanna
serious,
make
and
sure that
you
we
have,
appropriate guidance from board counsel.
at the
That's-
end of the day, this is a motion against you. You are in no way, shape, or form able to rule about a motion, rule about a motion about yourself.
okay,
You
just-
are unable to get in touch with board counsel. I think the
I am-
next person to do this is Ms. Zeno.
If you could just give me a few moments to reach her, just a reasonable amount of time. It's a pretty serious motion. There's another person I can call as well.
There is a motion on the table with a second. We need
It's
to
a pretty
take a vote.
serious-
It's a serious
We don't-
motion
we
that,
don't-
that requires discussion.
And if that's appropriate for me to recognize, I don't think it's appropriate for me to recognize because I think that that I'm entitled to a hearing.
After
You're
the chair,
incorrect.
Aaron, after the chair makes a ruling, any member who disagrees with it may move an appeal.
If you could just give me a moment because,
Do you want to borrow my book?
no, I have it here. I'm just going to, I think I'm getting closer.
If the appeal is seconded, the chair must state the question on it, clearly explain the exact parliamentary question, and allow permissible debate. Would you like me to appeal it for you, Aaron?
So I'm looking at Robert's
I can't believe this is
Rules,
happening in real time.
Section 62, removal from office. And it says, these are the procedures. The removal of an officer for cause under 63:1, or the discipline of a member for improper conduct, may require that the charges be preferred and that a formal trial be held. The full procedure for such cases is described below. The society has the right to investigate the character of its members and officers as may be necessary for the enforcement of its own standards. I'm in 63:2, nor any member has the right to make public any information obtained through such investigation. If it becomes common knowledge within the society, it may not be revealed outside the society. Consequently, a trial must always be held in executive session, as must the introduction and consideration of all resolutions leading up to the trial. If after the trial a member is expelled or an officer is removed from office, this is 63:6, the society then has a right to disclose that fact, circulating it only to the extent required for the protection of the society or possibly of other organizations. So 63:4 talks about what you have to prove in the disciplinary matter and
Ms.
what you
Sullivan?
have to prove, I'm sorry, I have the floor. 63:5 says, a member or officer has the right that allegations against his good name shall not be made except by charges brought on reasonable grounds. If thus accused, he has the right to due process, that is, to be informed of the charges, given time to prepare his defense, appear and defend himself, and be fairly treated. If the member is guilty of a serious offense and knows that other members are in possession of these facts, they may wish to actually quit instead of being voted out. When the good of the society appears to demand the departure of the offender, that can also happen. There's steps in a fair disciplinary process, which are set forth in 63:7. Most ordinary societies should never have to hold a formal trial, et cetera, for the protection both of the board and its members. The basic steps which must be made are those elements of a fair disciplinary process. Any special procedures should be built essentially around them. The steps must be followed in the absence of such provisions. As set forth, they are a confidential investigation by a committee, a report of the committee, a referral of the charges if warranted, formal notification of the accused, and a trial, and then the Assembly's review of a trial committee's findings. This should all be done confidentially under 63:8. So those are the rules that have a procedure for me for a fair disciplinary process.
Ms. Sullivan, but what you're neglecting to do is reading removal from office 6216, which all comes before what you read.
Okay.
Except as the bylaws may provide otherwise, any regular elected officer of a permanent society can be removed from office by the society assembly as follows. If the bylaws provide that the officer shall serve, and it goes on to talk about if the officer in question can be removed from office by adoption of a motion to do so, and C is a vote of a majority of the entire membership. So I'm not saying you are not entitled to a trial. However, that would be after you appeal the process if the motion passes to remove you. There's a motion on the table. You are required by Robert's rules to accept the motion. We can debate it. Our policy clearly states how a president can be removed from their seat. Aaron has written a resolution. There's a motion on the table. I ask that we have a discussion if you'd like, and then we vote.
So you read the wrong provision. You read 62:16. You have to read the bottom provision, which says, if the bylaws provide the officer shall serve only for a fixed term, which is what I serve, only for the fixed term of 1 year.
But our statute, our policy states, and he stated that you are
I
not.
didn't interrupt you. I'm so sorry.
But at the
May
end
I
of
be
the day,
recognized?
I'm sorry, I was just going to finish one really quickly. It says here, if the bylaws provide the officer shall serve only a fixed term, such as for 2 years, I only serve for 1 year, or if they provide that officers shall serve for blank years until the successor is elected, an officer can be removed from office only for cause in accordance with the provisions
We have clause.
described in section 63, which is the investigation and trial. So the motion is out of
there's a
order.
motion on the table.
I'm sorry.
It needs to go up for a vote.
Mr. Bugnanzi, did you want to say something?
Yeah. It's my understanding that if there's a motion on the table and it's seconded, you have to vote.
I'm sorry, but the motion's out of order because according to
You
Robert's
must
rules-
Doesn't work
recognize,
like that.
you must
Robert's rules.
recognize the
Our policy
motion.
states that we have a fixed term. She has a fixed term of 1 year.
There's a motion that's been seconded.
There's a policy
Can I-
on our books.
Can I just,
looking at
can
the
I just say
policy.
something
It's right
quickly
here.
to the people that
here,
are
right
watching
here.
at
You want me to-
home
I
and
highlighted
to the
it for
people
you.
that are in this room? This is precisely
Okay.
the circus
So why don't
that
we do
we're
this?
trying to
Would you agree
avoid.
to table the motion until I'm able
No.
to? contact
Absolutely
the board
not.
counsel?
There's a motion on the table.
it
Let
says right
Mrs.
here.
Zeno opine, since you shouldn't
It's
be the
against
one.
Robert's rules.
Against Robert's
What's-
rules, right
Not
here.
against Robert's
It
rules.
is
I
against
100%
Robert's
appeal what you're saying, and I'd like someone else to rule on
If she has a
it.
fixed term in the policy, which she has.
I
in
do
our
not agree
policy-
with what she is saying.
Policy
Let her
0152.
If you can't get in touch with the attorney, the next person to ask is Miss Zeno.
Well, you haven't
Please
given her a
allow
chance.
Miss Zeno to opine on our issue.
You're not letting
Did
her
you
to
not
opine.
say Policy
You-
0152?
It says right here.
Okay, she has a fixed term in here.
Why are you
A
not
president
allowing
or
the
vice
PA?
president who refuses to perform a duty imposed upon him or her by law may be removed by a majority vote of the board members present and constituting a quorum. That's our board officers policy 0152.
And who decides who, if she
There's a
he
motion on the
refuses to
table.
perform a duty imposed? That's your list.
There's a motion on the table,
You're
so let,
deciding before she has a trial
you're gonna
or
have a chance to
anything.
decide.
I'm saying,
You're gonna have a chance to
deciding
decide with your vote.
whether or not she fits into that category.
You're gonna
Robert's
have a
rule
chance-
says that she can't be removed without a trial.
Our
if
board
she has a
policy-
set term on the board policy.
Our board policy states, it also goes by state statute. There is a motion on the table that must be addressed. Ms. Sullivan cannot opine on a motion against herself. Either Ms. Zeno opine or we vote.
So the motion is out of order because Robert's Rule 62:16 requires that I have a trial and that I can only be removed for cause, and there's a
You-
procedure in
It's
section.
just
You
not true.
can't opine
So
on
can
your
I have a
own.
motion to open open for public comment.
No.
There's a motion on the
Anybody
table.
want to make a motion for public?
There is a motion on the table that must be dealt with.
Anybody?
I'd like to have,
So moved.
I'd like to have Ms. Zeno weigh in on this, because we cannot move forward
Can you just
until we
wait
resolve the
until I-
motion on the
it's really
table.
unfair
I'm sorry.
for her
I like to
find-
make a motion to have Ms. Zeno opine.
Let me try to get Dave.
I'll second that.
Let me get Dave, we already have a
Okay, so
motion
we
on
have
the
a second.
table. You have an incidental motion, which you're
So-
not on the previous motion.
Shouldn't we be taking a vote?
Let me see if I can get in touch with Mr. Disler. It would be helpful if you had told us you were going to do this motion so we don't inconvenience the public. Oh, hi, David. I'm at the board table. I'm just going to.
Private conversation
No,
with the
you can't have a
attorney in the
private
middle of a board
conversation in the
meeting
middle of
should
a
be on
board meeting?
speaker so we can hear what you're asking.
give advice.
Okay,
Well,
let him
we
give
need to
advice.
hear
We
it.
need
We're
to
in a
hear it.
meeting. Pretend she's here.
They want you to be on.
Yeah, absolutely.
Okay. Public. They want to get advice from the public. I'm going to put your loudspeaker. Dr. Lorenz made a motion to remove me as president. Can you hear me? Dave? Okay.
We can't hear him.
Oh, you didn't hear him say I can?
No.
Repeat that, David.
Yes, I can hear you.
Okay, perfect.
Under Robert's Rules of Order 62:16.
Why don't we tell him what the motion is first?
The motion is to remove me as president for cause.
It's been seconded.
And
With
it
a second.
With a second.
Yes, it's been properly seconded, but it says, "Be it resolved that Judy Sullivan should be removed as president of the Ramapo Indian Hills Board of Education for the following non-exhaustive list, which includes but is not limited to public admonishment and evaluation of the superintendent and administration, use of board letterhead for public statement without receiving board approval and without questions being posed to initiate a response, silencing board members during discussion in violation of Robert's rules, and excessively seeking legal advice without board discussion, resulting in an impending $500,000 yearly bill for legal fees." Did you hear that okay?
I did.
Okay. Robert's Rules of
No,
Order.
why don't we ask
No,
him
no,
to
it's
give us his opinion before you
Before
read
you read-
Robert's rules?
and-
He's the attorney.
And basically, 01, our policy, our board policy, this is Mr. Disler on the phone?
Yes.
Mr. Disler, our board policy 0152 states, "A president or vice president who refuses to perform a duty imposed upon him or her by law may be removed by a majority vote of the board members present and consulting a quorum. In the event the officer or president or vice president shall become vacant, the board shall within 30 days thereafter fill the vacancy for the unexpired term." And Ms. Sullivan is unrecognizing our motion, and she is refusing to allow Ms. Dora Zeno, our interim BA, to opine on it. She is insisting that she is the parliamentarian, even though this motion is against her.
And Robert's Rules of Order 62:16. Well, you were able to cite the policy. I can cite Robert's Rules, no? Robert's Rule 62:16 says, "If the bylaws provide that officers shall serve for only a fixed term," which I do, I only serve for a fixed term of 1 year, an officer can be removed from office only for cause, which is actually consistent with the policy that they just cited. That is neglect of duty in office or misconduct in accordance with the procedures, this is the important part, described in section 63. That is, an investigating committee must be appointed, charges must be preferred, and a formal trial must be held. And section 63 provides all of the details about investigation of trial, that it has to be done to the extent possible in private, not to cause unnecessary embarrassment to the society, meaning the board, that I have the right to know what the charges are, that I have the right to defend myself, and then a decision can be made. They even have rules about hearsay evidence, and the board, my position is the motion's out of order because Robert's Rules of Order say it can only be removed for just cause after a trial. So that's the question. They want the motion to be determined.
Mr. Disler, if I could just say one other thing. 63:1 says, as explained in 61 and 62, the removal of an officer for cause or the discipline of a member for improper conduct may require that charges be preferred. And only then is a formal trial to be held. We're not asking that charges be brought against Ms. Sullivan. The motion on the table is simply to remove her as president of this board.
So 63:1 is the preamble to that section, which has a may provision, because 62:16 says that you can use that provision as an option in the event there's not a fixed term. So the reliance on the word may is misplaced. If you go directly to 62:16, it clearly states that if you're removing an officer who has a fixed term, they can only be removed for cause, which is consistent with our policy says, and it has to be in accordance, it doesn't say may, it says in accordance with the procedures described in section 63. And it says that is an investigating committee must be appointed, charges must be preferred, and a formal trial must be held. So I take the position that the motion's not proper because it's not consistent with Robert's rules.
Mr. Disler, there's a motion on the table with a second.
Yes.
We're supposed to vote now. Is that correct?
Do you want to take some time to look at this, Mr.
No,
Disler?
can he just answer? Let him answer.
We can't hear.
If it is okay with the board, if we can call maybe a 5 to 10 minutes recess, just so I can look into this. This is a complicated issue, and if I just have 5 to 10 minutes, I can call the board president back on her cell phone. If you want to take a 5 to 10 minute recess, that may make sense. If I'm understanding the question correctly, can everyone hear me?
Yes.
Just so I'm-
You're saying that you
Okay.
want to take a 5 to 10 minute recess so you can look into it.
I think if I just have a 5 to 10 minute recess, the board wants to take that. If I'm understanding correctly, there is a pending motion to remove the board president for cause with charges being read, and a second, and now you're just asking for the process.
No.
Do I understand?
No charges, Mr. Disler.
But it does say
Just
for
to
cause.
just to clarify, Mr. Disler, so that you're clear, there's a motion and a second on the table to remove the board president. That is all.
No, that's what that motion says. I'm looking right at it, David. It says for the following non-exhaustive list. And they list a whole
We're giving the
list-
reasons
excuse me.
why we want to remove you.
Yes,
We are
for just
not,
cause,
we
for
are,
just cause.
we are
I
not
did not
asking that
interrupt you.
charges
I did
be
not interrupt
brought.
you. I did
You
not
interrupt, you did interrupt me. We are,
sorry. I
you
was
did.
trying
You
to-
interrupted me, but that's okay. So
So-
we are not asking that, I want to make sure he's clear. We are not asking that charges be brought. We are simply asking that you be removed from office.
But there is
cause.
a reason. They have
They're
this
giving
reasons, these just cause reasons. Go ahead, David.
But Mr. Disler, if there's a motion on the table with a second, how are we going into a recess? We need to take a vote.
Again, I just want to be clear, if I'm understanding it real quickly, there's a motion to remove the board president for a list of reasons, and there's a second, and now the board is asking you to opine. One, what is the process to remove the board president, and can this vote move forward as properly noted second? Am I understanding correctly?
I can't hear him.
Understand the last part.
You want to repeat that, David?
So if I'm understanding the board's questions correctly, there is a motion to remove the board president based on a list of stated reasons, and that motion is seconded. The question the board is asking is what is the process to remove the board president, and can they move forward with the vote as presently set forth?
No. We are just asking if we can have a discussion and a subsequent vote on the motion.
So, why don't you take 5 or 10 minutes, David, to look at this, and I can call a
No,
recess?
but we're asking what his opinion is. There's a vote.
He needs a few minutes to look.
There's a vote, there's a motion on the table with a second. How do we go into recess when there's a pending motion on the table?
Because the board council needs 5
Can
minutes.
council please opine, please, on that question, the question of how we go into a recess when there's a pending motion?
I think someone will just make a motion right now, if we could just go into recess think that would be appropriate, just because I assume this is a complicated matter and the board wants to do it correctly. But I can just have 5 to 10 minutes, just so someone can move to recess, just so the board is anything to review the matter. I think that's appropriate under the circumstances.
I have no objection to 5 to 10 minutes. It's a pretty serious motion. Anyone else have an objection to the board council taking 5 to 10 minutes?
No.
Okay, so what time is it? It's 9:20. You'll call me back, David, in about 5 to 10 minutes?
Don't we have to vote on taking a recess?
I just said, does anybody have an objection?
Well, I'm not
That's
sure,
not
I'm
a
not sure that I want to go into recess. I want him to give his opinion on the pending motion.
I think what he said was he needs a little time. Would you not deny him 5 to 10 minutes to remove the board president? It seems reasonable to me.
If the board doesn't want to go to recess, that's fine. I still need about 5 to 10 minutes. I can jump off the phone. You can stay in public if you'd like, but it's up to the board. Either's fine. You can stay in public. I just need a few minutes just to look into this.
hear him.
He's asking for a few minutes.
We don't have to leave. We could stay here and talk. It's not like we need to have a recess.
I'm just unclear as to why he can't make a decision on whether or not this motion that's pending cannot be voted on. Why Ms. Sullivan has the right to say, I don't recognize the motion.
He's asking just for 5 to 10 minutes.
For 5 to 10 minutes to look at what? I'm unclear as to
He wants to
what.
make sure the motion is valid.
I'm unclear, Mr. Disler, as to what you need to review.
So if you're asking me, I'm trying to right now, both review the statute and the case law under the statute and, potentially and Robert's rules if they apply or not, right? So as you, just to give the board background, so obviously statutes always control over the board. You're required by law to follow statutes, they will control. You as a board annually approve Robert's rules as when statute or your policies don't control, then you default to Robert's rules. So what I need to look at right now, because there is a challenge, right? There's the statute in place that is relatively broad about the removal of the board president. You have your policy in place that would be second in line to statute. And if those don't answer the question, then I have to move on to Robert's rules. So I'm just going to go through, I just need about, I'm hoping about 10 minutes to go through both the statute, your policies, and Robert's rules to see which would govern here.
State statute and our policy are stated exactly the same.
Okay, so why don't you call us back, David, when you're done with your review? We'll try to move on to something else in the agenda.
We can't move on. There's a motion on the table.
Pending motion, if there's a pending motion, I don't know if you can move on.
So do you want to call a recess?
A recess.
Yeah, I know, you suggested a recess, but they don't want to do that.
Or if you don't want to recess, then you could just, you could just wait, right? There's no time limit for an open motion.
We'll just sit here for
If
10
the board
minutes.
wants to stay in public, that's fine. I just figured a recess made sense for everyone, but there is an open motion, so I don't know if the board can currently move forward. But I think either a recess or just wait, whatever the board prefers. But I just need time to be able to review all this.
Okay. What are we doing here? Do you want to take a recess, use the restrooms? Anything like that, get a drink?
No, I think we should stay here. There's a motion on the table.
Okay, so he can't research and talk to us at the same time.
We should hang up.
I can't, I would prefer if possible to.
Okay, so why don't you call us back when you're done? Okay, thank you.
Ms. Sullivan, may I speak?
Yes.
So this policy that they're talking about, it says a president or vice president who refuses to perform a duty. I'm not sure that you've refused to perform any duty, so I
that's
don't know.
where my position is the trial comes in. This is the United States of America. We should be modeling good corporate governance for our
I mean,
students.
the people who are saying that this applies to you, they're not your fans, so they're going to say anything they can that's bad about you, and that's pretty unfortunate because I think you've been doing a banner job, even though they don't agree. But it clearly says right here, a president or vice president who refuses to perform a duty that imposed upon him or her by law. I don't think you've refused to perform a duty that's imposed by anyone.
Thank you.
Are we considering the motion now?
No, we're
she's
waiting
just
for the
making a
attorney.
comment. Um,
It's unfortunate because when we voted you in as
We're
president,
either having discussion or we're not. Are we having discussion?
we are having discussion. That's what we're doing right now.
Okay, so answer it, so then we're considering
So
the
we're
motion.
Considering the motion?
If
No.
you're going to sit here and if she's going to make statements, if Miss Mariani is going to make statements, then we're considering the motion. You're allowing her to pontificate, you're allowing her to make comments about the motion, then we must be considering it.
So we've
let's
all been
have
talking,
discussion.
but suddenly now that I've chimed in, it's a problem. Although every one of you have been talking.
We're not talking about
Yeah.
the substantive
I'm reading
motion.
exactly, I am reading exactly
Policy.
what you just said, a
But no,
policy.
you're making comments on how she
Well,
performs
forgive
her
me.
duties.
No, she's
Forgive
not.
me.
She's
I
making
can't help
comments-
myself.
She's making a comment about the appropriateness of the motion. She's raising the point that there has to be just cause and there has to be some failure of duty that has to be performed.
Saying you're doing a banner job is not making a
Well,
comment
you're saying
about
she's
your...
doing a terrible job.
That's not what I said.
So, well, then
That
why
is
would we
not what I
want to
said.
remove her?
Those words never came
So-
out of my mouth,
Well,
Doreen.
I'm looking at this note that's right here in front of me, and it pretty much says that.
It's not my motion.
Okay, so it's
Does the
Dr.
board-
Lorenz's motion
Then why
that
do you
I'm
have to
looking
put your 2
at
cents in?
and considering.
And you're accusing Ms. Sullivan of some very serious things in here. Basically, she has rung up $500,000 in yearly legal bills just by herself. So
So we should
You're-
have this conversation as a board. A motion on the table that's been seconded,
we
then we
don't
would
know
have
if
it
it's
as
a
a
valid
discussion.
motion.
There's no such
But
thing
you're
as a
still
valid motion.
talking, we're still having discussion, so is it valid or it's not valid?
No, they think
That's
they're
why the
commenting
lawyer
about
needs
the
to rule
appropriateness
on
of
whether
the
it's
motion.
valid or not. Yes, and you're still talking.
I'm not.
Yes, you're always,
I'm not talking about the...
this is what
Does the
we're
board,
talking
in
about
the
what we're talking
interest of
about, okay?
time, want to move on to anything else while we're waiting?
I don't think we can.
I don't think we
wanna sit
can,
here
there's a
and wait
motion on the
and-
table.
We have public comment coming up.
I wish we could.
You don't want to discuss anything else?
I wish that we could, but we have a motion on the table.
So we'll wait 5
Do you want
minutes.
to withdraw the motion and refile it later so we can move on to other things?
You've asked that already.
So is that a no?
It's an absolute no.
Okay.
Then we'll sit here and wait.
It's very unfortunate.
We'll sit here in silence and wait.
Ms. Sullivan? Maybe you should leave your phone here in case the attorney calls.
We're in the
That
middle of
how-
open session.
How long was your husband on the Board of Ed?
6 years.
Making your nose run?
I know, I know. Seems like most of them are different than this. We got lucky.
It's unfortunate. No, actually unlucky.
No, I'm with you.
Kerry Wright just texted back and said she's available. I don't know if this is her. Let me see. Hello? Hi. Yes, Kerry just texted me too, saying she was available now. Do you want me to put you on speaker or? Okay, hold on. All right. David's on speaker now. David Disler?
Can the full board hear me?
Yes.
So, my colleague Terry Wright and I she just got out of a board meeting, and her and I had the ability to kind of walk through everything here. Terry's also on the line, so if you have any questions for her as well, that's fine. But I will kind of walk everyone through our thought process and our deliberation and kind of walk the board through where we are. So as I mentioned before, I asked for the 5 to 10 minutes to just do a little research. The order of how board policy typically works is that, again, at your annual meeting, you as a board follow Robert's rules. By policy, you've also indicated that you will follow Robert's rules, but you do so when it doesn't conflict with your policies or the law. And so the order of which we look as attorneys is we first look to the law. We then, after, if there's no issue with the law, we go to your policies and then Robert's rules. And so where we started with our look is both your policy and the law. And I'll just read to the board what the law says. So it's 18A:15-2. says a president or vice president of a board of education who shall refuse to perform a duty imposed upon him by this law may be removed by a majority vote of all the members of the board. It then continues about filling the vacancy of the board president. And so where we have arrived is that the law appears clear in that it's a majority vote by the board to remove the board president. What I will caution the board, of course, is you may only remove the board president if that board president refused to perform a duty imposed upon him or her by law. Now, as the attorney, we do not obviously make that decision. That rests with the majority of the board. But we, of course, must warn the board that that could be challenged by way of a petition to the commissioner being the ultimate decision maker whether the board president violated the law or not. So certainly, we want to be clear that the board could be challenged on this. But, of course, we believe the law is clear that a majority of vote of the board, whether the board president fails to perform a duty imposed upon law, will control. I believe the motion, if I remember correctly, what was described to me by the board was there is a motion to remove the president. They then list a list of reasons, and then there's a second to vote. So what the board would be voting on then by statute is, did the board president refuse to perform a duty imposed upon him or her by law? But the vote can go forward. And then obviously, as I mentioned, it has the potential to be challenged.
Okay, so just a couple of questions then. By law, meaning, are any of these reasons imposed by law? Public admonishment and evaluation of the superintendent and administration, that would be a law. Use of board letterhead for public statement without receiving board approval, that would have to be a law. And then silencing board members during discussion in violation of Robert's rules, that would be a law. And excessively seeking legal advice without board discussion, resulting in a pending legal bill for $500,000.
So, if you're asking, sorry, Judy.
So I'm asking your opinion if any of these are by law duties that have not been observed by me. Is there a law?
So that is the standard. If you're asking me, that's the standard by which the board should be voted upon, right? And that has the ability to be appealed to the commissioner. If you're asking me right now, I can't. One, we would have to actually look into it. I can't opine presently before the board. It's really up to the board to review that. If the board wants our legal advice going through that, we would ask, obviously, time to review each of these, look at the case law and the like. But really, it's the standard from which the board, which would be removed to the commissioner, and the commissioner would be the ultimate determining factor here.
So, Mr. Dissler, is it basically your opinion that there is a motion on the table that is following the state statute as well as our policy, and that our policy is the rule of this board, and that being that there is a motion and a second on the table, we can have discussion and then vote on this, and if Ms. Sullivan does not like the way the vote went, then she can appeal to the state commissioner?
That's correct, right? So if the board has the right to move forward with this vote, but the board obviously has an obligation to follow the law. If the board fails to do so, the remedy would be a petition before the Commissioner of Education to determine whether the board did or did not follow the statute when it voted on the present resolution before the board.
So let me ask you then, when does Robert's rules come into play that talks about the right to a hearing to establish the just cause? 62.
So Robert, sorry. So Robert's rules come into play both by the board when the policy isn't clear or the statute isn't clear. It's similar to a regulation, right, where you first go to the statute and then you move to the regulation.
Right.
So in our view, the statute here is clear that it's a majority vote by the board. Right? So since there is a motion presently pending, the statute says it's by a majority vote, therefore a second, and therefore, in our view, the statute's clear here. We wouldn't go through the Robert's Rules procedures of removal of an officer, which, as we know, requires an investigation committee, a trial, and the like. The statute here does not call for any of that. It just simply says majority vote of all members of the board.
So the statute says just cause. How do you establish that? Failure to perform a duty imposed by law? Is this board, is it your recommendation to the board that the board should make this decision, that there's been a failure to perform a duty by law without the advice of counsel?
It's up to the board if they want the advice of counsel, right? They're certainly permitted to go, the board's permitted to go into executive session under the Open Public Meetings Act if they would like to kind of individually discuss this resolution, but that's on the board. If the board would like that, we're certainly willing to have that discussion. If not, the board, can move forward with the vote. It's whatever the majority of the vote so desires.
So board policy says that I, as board president, can ask for advice and counsel from your firm. I am specifically asking you for advice. Do any of those stated grounds
Point of
fall
order.
under the definition
Point of order.
violation of law?
He is not your attorney, Ms. Sullivan. Point of order. He is the board's attorney.
So public admonishment and evaluation of the superintendent and administration, use of board letterhead, silencing board members, and raising excessive legal advice bills. For those 4 areas, is it your counsel that we should make that decision without your advice about whether there's laws that have been violated there?
That,
Is it my advice whether I should opine on this? Again, that's up to the board. I can't be attorney, right? So we will do as the majority of the board and the will of the board would like. Again, my recommendation is if the majority of the board would like our advice, then do so in executive session. That typically is how the attorneys provide advice. But again, it's whatever the board would like is what we will do.
Okay.
And again, the board does not have to have our advice. If the board wants to move forward, that's up to the majority of the board.
I understand. Okay, so if the motion passes and I'm removed, what happens next? Who runs the rest of the meeting? The vice president?
At that point, the vice president would, similar to if the president is vacant for a meeting, the vice president would run the meeting.
So the petition, if the petition is filed challenging the decision, how quickly does the commissioner make a decision on this? Is it
It varies. If you're asking me so it can be done by way of an emergent, theoretically, or it could be done a normal petition. Typically in these, it would get assigned to an administrative law judge, and then that process would be up to the administrative law judge.
And could the board president file her application on her own? How would that work?
Could the board, the answer is yes, right? Anyone can file a petition if you with the commissioners, certainly the board president could do so.
Okay. And so the commissioner would then, would there be any penalties that could be imposed, or is it just the reinstatement?
That is up to the commissioner.
Oh,
Can I ask Mr. Disler one more question?
sure, Ms. King?
Mr. Disler, is it possible, if the motion passes, after it's voted on, can someone make a motion immediately for a new president? That's possible too, correct? Because it says within 30 days, correct?
Ms. King was asking, could a motion be immediately be made to install a new president rather than going to Ms. Anch as the vice president to run the meeting?
Let me pull up your policy on election officers.
I think there probably is a policy that says that the vice president runs the meeting in the absence of the president somewhere, under duties perhaps?
But it states in policy 0152 that the president needs to be replaced within 30 days. If the motion passes.
That's what the policy says. The question before the president is, can a motion be made immediately? And that's what I'm just checking the policies now. Bear with me. your present policy, it advises that it simply just must be done within 30 days. If you're asking whether a motion could be made right away, I don't see a reason that it could not be, does not interfere with your policy. If you're asking me what would be the process if that motion isn't made, it would be the vice president runs the meeting. So if the vote passes, the vice president will take over. A board member then theoretically could make a motion to fill the vacancy of the board president.
So let me just look at policy 171, which says at the bottom, the vice president will preside at board meetings in the absence of the president and shall perform other duties as shall be assigned by the board. If the president or vice president position becomes vacant, the board will, within 30 days, fill the vacancy. If the board fails to fill the vacancy, the office will be filled in accordance with law. When the office of president is vacant, the vice president shall serve as acting president until a new president is seated.
That's 0171.
Yeah, I'm not sure if that affects anything.
It's 30 days or 30 seconds.
1 second.
Mhm. It is a shall sentence. The vice president shall preside at board meetings in the absence of the president.
But isn't that when you miss a meeting?
Don't know.
Can we move ahead with the motion? I think he opined.
He's just looking at this last
So
question.
there is no question. So if you're asking me a review of your policy, it's my view that a motion could be made. So by policy, you are required to fill within 30 days, or the executive county superintendent will do so. A motion could be made at this meeting to remove the president, and if that passes, the vice president then would be seated in that role, but a motion could be made to elect a new president, at which time, if that passes, then the new president would be seated, and then the vice president would remain the vice president.
Okay, got it.
But I didn't hear that.
He said the motion can be made.
The motion
Can be made. Can be made.
President,
Mhm.
Right.
and the vice president what? Stays with the
So-
vice president.
Then the president, if they vote in a new president, then the president continues to run the meeting
Right.
tonight. Yep.
And then what happens, once it's appealed, if it's in the president's favor, then they
Then-
come back in?
Yeah, the president gets reinstated, I'm assuming.
Ms.
That's
Sullivan?
correct. If the commissioner has the commissioner does have the ability to reverse the board. So then in that case, the commissioner, but again, the commissioner has say over the full board, right? Because the board is an entity that falls under the state of New Jersey, which is governed by the commissioner and the laws of the state. So yes, the commissioner's ruling will be binding on the board, obviously appealable to the appellate division and thereafter the New Jersey Supreme Court.
Okay, got it. Everybody clear?
Ms. Sullivan?
Yes.
May I ask a question of the attorney?
Sure. This is Miss Mariani.
So, can you hear me?
It's a little, if someone can repeat it after you speak, I would appreciate it.
Okay, my
It's a
question-
little garbled.
If you can repeat it.
I'll repeat it for her.
My question is,
My question is,
if these things that are on this motion
if
are
these listed offenses are on this
are
motion,
inaccurate,
are inaccurate,
it's just someone's opinion,
it's just someone's opinion,
does that matter? I
does
mean,
that matter? In other words, she's pointing to the
So,
list
of
of,
course, so presumably the list is in the motion is the reason set forth that the board will be voting on, right? That's the resolution before the board. So there are two things, right? The board has to follow the statute. So then, as I read before, shall cease to perform a duty imposed upon him or her by law. So that's number one for the board's consideration. And then, of course, by law, any public entity cannot make a decision that's arbitrary, capricious, and unreasonable. And so obviously if the reasoning by the board was arbitrary, capricious, and unreasonable, that also could theoretically be overturned.
oh, that's a really good point. So the standard that the board will be measured upon when I file my appeal, if I lose, would be arbitrary, capricious standard. So the board should be prepared to prove that all of these items, the public admonishment and evaluation of the superintendent and administration, the use of board letterhead for public statement without receiving board approval and without questions being posed to initiate a response, silencing board members during discussion in violation of Robert's rules, and excessively seeking legal advice without board discussion, resulting in an impending $500,000 yearly bill for legal fees. So the standard of review would be if the board made this decision under an arbitrary and capricious standard.
So, two things. So any vote made by the board is always judged on the arbitrary, capricious, and unreasonable standard. And of course, I also will remind the board that you do have the ability to go into executive session if you'd like to obtain attorney-client advice, right? Because under the attorney-client privilege exception, we can have this discussion in executive session as well. So I do want to give the board that option if you would so like.
Thank you.
Any other questions for the council?
My last question is, after we hang up with this phone call, are we discussing this? Can we?
Yes, we're going to have discussion on the
Okay.
motion because the council said that the
Okay.
motion can be entertained.
Okay.
But I can stay, maybe you should stay on the phone, David, in case other questions come up.
That's certainly up to if the board would like. I'm happy to do so.
Mm-hmm. Okay. All right, so let's have board discussion on the motion. Does anybody want to be?
I would like to speak.
Heard? Ms. Mariani? Sure.
Um,
Why don't you bring the phone, pass the phone down there so he can hear you in case he has questions or you have questions. And we can pass it around to whoever's talking.
Hello, this is Doreen Mariani. I am not an expert on Robert's rules, but I was under the impression that the board president is in control of the meeting, and the fact that this says, hello? Hello?
I can hear you.
Oh, okay. I hear some background talk. I didn't know if someone realized they're going to be in public here. So I was under the impression that the board president has the right to have control of a meeting, and that when she has silenced board members, it's been because they continue to interrupt people. They continue to jump in and act as if they are the president. So I feel like she had the right to do that. Am I correct?
So again, so the board president has the ability to run the meeting. There's no question about that. Whether the board president utilized that authority correctly, again, that's up for the board, right? So if you're asking, can the board president run the meeting? Yes. Can the board president do so in a way that is supposed to be orderly? Certainly correct. But whether that authority was used properly, that's for the board to decide.
Okay. And then my other question is, I believe that Ms. Sullivan had the right to address the community in that letter, and I would have also assumed that the rest of the board would have been happy to know that concerns for the public were put at ease with that letter. And I believe that she was given the okay from board counsel. Is that accurate?
I'm not sure what letter we're referring to. My apologies. I may not have seen it. One of my colleagues may have handled it. So my apologies. But I'm not positive on the letter being asked.
Okay.
So I'm on the phone as well, and I did have discussions with President Sullivan about that correspondence, and advised her that I believed it was lawful for her to send that communication.
Okay.
Could you repeat that? It was a little garbled, Ms. Mariani. What did she say?
Can you repeat that, Ms. Wright?
Sure. I had communication with President Sullivan about that correspondence and advised her that I believed it was lawful for her to send it.
You believed it was okay for her to send that. Am I hearing you correctly?
That is correct. You are
Okay.
correct.
Okay. All right. Thank you very much. I'm done. I'll pass the phone over.
I have a question. So, Ms. Wright, this is Helen Cool-Cordis. My question to you is, In what capacity did Ms. Sullivan ask to write that letter on Ramapo Indian Hills Board of Education letterhead representing the Ramapo Indian Hills Board of Education?
She requested it in her role as the board president. By policy, she is permitted to speak on behalf of the board, and that is the capacity in which she advised she was requesting.
And speaking on behalf of the board without consulting the board or asking the board what our feelings were, is that speaking on behalf of the board?
As the board president, she is able to make statements on behalf of the board.
Without discussing this letter that she put in singular, in her own I terminology in this letter that went out to the entire school district, that is permissible because she's the board president?
Yes, as I said, as the board president, she has the authority by your policy and by law to speak on behalf of the board.
Okay.
Ms. Wright, this is Vivian King. Did you see the letter before it went out?
Yes, I did.
You saw the whole letter and the statements about $3.3 million with no citation as to where that money had come from?
I did see that as well.
And you were okay with the...
Provided
I'm sorry, go ahead.
I was provided with documentation from President Sullivan about the details that went into the letter. I was not provided with the specific calculations that went behind it, but the specific that were included in the correspondence came from President Sullivan.
Okay. And I don't know if I have any other questions. Thank you very
I
much.
do.
You're welcome.
Sorry, it's Helen again. So just to understand, that letter that Ms. Sullivan distributed to the RIH community was on behalf of the Ramapo Indian Hills Board of Education, not from Ms. Sullivan. Is that correct?
My understanding from speaking with President Sullivan is that she was looking to provide a statement on behalf of the board to address the particular issues laid out in that correspondence. So,
I'm just bringing up the letter.
I'm sorry, are you
Yeah, I'm just bringing up the letter because I'd like to know, in the letter, I believe she states that she's sending the email on behalf of herself, not the board, but I'd just like to make sure that my facts are accurate.
I'm going to apologize in advance. I do not have it in front of me. As you could probably hear, I'm in the car driving from another board meeting.
Yeah, I have it in front of me. While I read this, do you want, somebody else want to do it?
Does anyone else have any questions to the lawyer?
Ms. Wright? It's Kim Anch.
Yeah.
So, so you're saying that it's policy 9120, public relations program, in which the board president is allowed to put out a press release or a statement on behalf of the board, correct?
That's correct.
Okay, thank you.
So this is Ms. Sullivan again, Ms. Wright. That leaves, in my opinion, and we are discussing the motion at this point, only 3 other items: public admonishment and evaluation of the superintendent and administration, silencing board members, and legal bills. So wanted to defend myself with respect to the legal bills. I do not approve the legal bills. The administration approves them. I sometimes don't even see them come in or go out. So you would have to be prepared to defend a claim that I would file with the petitioner that you acted in an arbitrary and capricious way in saying that I'm responsible for approving these bills, but I do not approve them. Someone else does, the superintendent and the business administrator. To me, that's arbitrary and capricious. If those bills were not approved, then you might have a different situation. And I don't think that you can defend that. I don't think you can establish that because they are approved by people, not me. I'm not the person who approves those. With respect to silencing board members during discussion in violation of Robert's rules, I don't think there's a law anywhere that says that I violated the law by silencing a board member. First of all, you haven't established that. There's really no evidence here. There's no copies of transcripts. There's no testimony about when that happened. And I've actually been criticized in the public for letting people talk too much on the board dais. And so there's no law that's been violated when I quote unquote silenced someone. I attend every board meetings. I try to ask if anyone has any questions. I entertain. Our meetings go very late because there are so many comments from the board members. So I will produce the time period for all of the meetings that I have presided over with the Commissioner of Education, and I will demonstrate to her that I have gone 1 o'clock in the morning to allow all board members to speak. So if you're confident enough to defend that I silenced someone in violation of law in light of the length of our meetings, in light of the number of times I allow people to speak, once in a while, if I said, look, we really have to move on, the meeting's getting late, if you are prepared to defend that as a board as a violation of law, then go ahead and vote for it. A vote like this, let me go to the last one. Public admonishment of the superintendent. So I don't know of any law that says that there is a law that says you can't admonish someone. I don't think I ever did that. Again, there's no evidence before the board that I did that. But if you're confident enough that you can defend silencing board members in violation of law, the legal bills I don't approve, board counsel already told you that she approved that letter going out. She even actually helped craft it with me, just so you're in full disclosure here. And what else? Those are your 4 bases. So if you're prepared to defend this board, which I will file a petition tomorrow with the Commissioner of Education, it could impact a number of things as well. You're trying to hire an interim superintendent and you kick out your president at the same time? That looks ridiculous. Why would you do that during this delicate transition time? I've been on the board for almost 4 years. I was the chair of the ad hoc committee to appoint the first interim superintendent, the next superintendent, and I helped support the board president at the time to hire Dr. Dionisia. And there is nothing I have done that has interfered with that process. I've tried very hard to immediately take action to try to support that. It could also impact your insurance. So if I bring a petition tomorrow to challenge this, it could affect your insurance rates, your coverage. I'm also working very closely with the negotiations committee right now to negotiate our supervisor's contract. I attend every meeting. I support the board members on that committee. That could negatively impact the perception of how those negotiations should go. I ask you to think very carefully about this decision. Being a board president is also a huge, huge amount of work. It's at least 10 to 15 hours a week. You have to attend all the meetings. You have to attend now these interviews that we're hoping to set up for the superintendent. You have to be prepared to take calls late at night if something happens when the superintendent calls. You have to be able to deal with board member complaints. It's a very delicate time, and I implore you not to do this. It's gonna harm so many things right now. It's not necessary. What do we have left? We have October, November, and I think one meeting in December. I'm almost done. So I don't think this is really a great idea. It's not a good look for us. It's gonna cause disruption, and I'm almost done. Let me transition the board into the new interim superintendent position. I've got tremendous experience in doing that and steering the board to that decision. But again, I want to caution the board. If you're prepared to prove that I violated law, and she's already told you one of your bases she gave counsel to, silencing board members, I don't think there's a law that I violated there. Legal bills I don't approve. The public admonishment of the superintendent and administration, I don't think there's a law that says that that can't be the case. Even if there is, I've never publicly admonished anyone. So if you're really confident that you can prove this by law and not involve the district in a case that's gonna have your name on it, right? That's gonna go in the books, then go ahead and do it. But I implore you to think carefully. Any other board members have any comments on this?
I'd just like to say that we are at a very delicate time right now. We're in a situation where we have an inability right now to attend to the board business. And I think it is in the board's best interest to get better leadership in this seat so that we can do the business of the board and move the district forward. There is an issue of there being constant chaos. You all saw what just happened when a motion was brought to the table and people were stifled until we finally got board counsel on the phone.
Would you respect the speaker, please? Go ahead, Ms. King.
I'll wait till they're done. There is an issue with there being people not being allowed to speak. There's an issue with there being chaos in the administration because of some of the things that are happening by the board president. I do not agree with the assessment of Ms. Wright. I'm sorry, I do not. I believe that the letter that you sent out on board letterhead was done in error. I believe that there was no question posed to the board that had cause for you to send out a letter on board letterhead. I believe that you were speaking on behalf of the board without bringing the board in to discuss it. I believe that even though you do not approve legal bills, you are listed on the legal bills on itemized lines showing the excessive nature of you speaking to board counsel. It's time for a change. It's time to bring some calmness back to this board. It's time for the board president to be able to collaborate again effectively with the superintendent. It is time to get back to business. And I believe that everything that Dr. Lorenz has stated in his resolution can be effectively brought, to fruition if need be, if the appeal is recognized, if the motion even passes. We haven't even voted on it yet.
I just have one question. Ms. Wright, did you help Ms. Sullivan draft the letter that went out to the community?
Ms. Koulikortis asked if you, Ms. Wright, helped draft the letter that went out to the community.
I personally did not. My office did.
Did you hear that? Her office.
Yeah, because I'm noticing in an email that I pulled up here, it says that Ms. Sullivan stated that as board policy allows the board president to speak on behalf of the board, it is permissible to place this on board letterhead and publish to the board's website and to parents. Board counsel assisted me in drafting the letter.
Yes, is that not consistent with what she said?
I
Oh,
couldn't hear her, I'm sorry.
They're saying that your office did not help me, but if
No,
there was another attorney?
This email states that Miss Wright, Carrie A. Wright, at 11:52 a.m., wrote to you, Miss Sullivan, as board policy allows the board president to speak on behalf of the board, it is permissible to place this on board letterhead and publish to the board's website and to parents. Board counsel assisted me in drafting the letter. Are you the board counsel that assisted Miss Sullivan in writing this letter? As her letter states, it is you.
So I wrote in the email, if I understand the
So
question
I'm
correctly.
asking Miss
I know,
Wright
but
the
she
question.
can't hear, so
Okay,
it's just
so
repeating.
I'll repeat it if she
Okay,
needs
she
me
wants to
to.
tell you the question herself.
Yeah. Ms. Wright, it's Helen Koulikortis again. I'm going to read the email again. So Ms. Sullivan sent a email to the board stating that Carrie A. Wright at 11:52 a.m. I also shared below board counsel advice in the distribution of this letter. This has and will continue to be shared with various news outlets. As board policy allows the board president to speak on behalf of the board, it is permissible to place this on board letterhead and publish to the board's website and to parents. Board counsel assisted me in drafting the letter. Were you the attorney that helped her draft the letter?
So as I said, I don't think you could hear me. I did not assist directly in drafting the letter. I reviewed it afterwards, and I did have someone in my office assist her. So it was drafted by board counsel. It just wasn't me personally.
Okay, thank you.
Ms. Sullivan,
Yes.
I
Dr.
just
Lorenz?
want to get back to how I began this motion because I didn't want to have to make it. I don't want to have to be here. This is a difficult situation to be in. I feel like this is our only option. And so for other board members, I want you to think about the conversations that you're going to have back in your communities. And the conversations that you're likely going to have will result in this sentence: why did you wait so long? And that's where we are. That's why I'm making this, why I made this resolution.
Anyone else
Ms.
have any
Sullivan, can I
comments?
say something?
Ms. Anch wants to make some comments.
No, it doesn't
Okay.
have to be for that. So for you to say, Dr. Lorenz, that people in our communities will say, why did you wait so long? Maybe that's the people you know in your community. My community will not say that. My constituents who voted to put me up here to speak on their behalf will not say that. I almost have no words. To look at this motion that you handed us, you're accusing her of running up $500,000 in legal bills. Everything that she just spoke about and that Ms. Mariani spoke about, this is your opinion. You did not vote for her to be president. You would not be bringing this motion, we all know. You wouldn't be bringing the motion if you didn't know you had enough votes for it to pass, would you? So, it's disgraceful to me that someone can be accused of all of this by people who didn't want her as president in the first place, never tried to work with her, constantly question everything that she has said. There have been emails and emails since day one asking, why are we doing this? Why aren't we doing it this way? Oh, we don't believe you. We want to hear it from legal counsel. Then if she gets an opinion from legal counsel and sends it in an email to all of us, then all of a sudden it's like, well, I don't want to hear that from you that legal counsel said that. I need to hear it directly from legal counsel. So for a bunch of board members who think that she utilizes board counsel too much, that's all you ever want to do. That's all you did when Mr. Fogarty was here. That's why we had board counsel at every board meeting before I was elected to the board. He was here all the time. It was costing thousands and thousands of dollars so that you, board members here tonight that brought this motion, could use him like your legal counsel. So the fact that you can bring a bunch of charges that don't have to be substantiated, and then we can hear how she can be removed and then appeal after. So convict first and trial second. And if you're comfortable doing that, then let your constituents see you do that. And United for Students, let your constituents, let them see that during an election season. All you talk about is transparency. You come up with a bunch of accusations, nothing here to back it up. What's transparent about that? There's been nothing transparent about the superintendent search, nothing. That's all you talk about, transparency, transparency. Ms. Sullivan has been transparent to a fault, and I have told her many times, I've told you, right? You don't have to answer every single question. You don't have to have a million emails about this you literally harp on every last thing. Everything since January 5th. Everything. So to say that there's chaos, yeah, there is chaos. And you're going to sit here and say there's chaos and it's all because of Judy Sullivan, the board president. Look at yourselves. Look at yourselves. And you can sit here and smirk all you want, like you always do. Yep. You can sit here and do that. It doesn't matter. It doesn't matter what I think of you. It matters what the voters think of you, and it matters what everybody that watches, whether they're here or online, what they see you do. So you can sit here and try to act like the voice of reason right now. Yes, get rid of the board president. She has 3 months left. Go ahead, do it. I hope you feel good about it, because everyone sees what you're doing.
I have a question.
Yes,
Ms. King asked the question to Ms. Zeno earlier about the comparison of the finances from last year to this year, I believe is what the question was. Can we have an answer to that question, Ms. Zeno?
This is my statement. In familiarizing myself with the district's operations, because if you remember, I'm only here a little over 2 months, I'm in the midst of analyzing and comparing our expenses for the prior year, 22-23, and seeing the trajectory that we're going in the 23-24 school year. And your legal expenses in the first half of last year were significantly lower than the second 6 months. I'm not saying what the reasons were or what the dynamics entered into that comparison. In the month of July, which is the only month we have legal fees for, we're already at, I think it's like $48,000. So if you want to multiply that times 12 months, and you assume the same level of interaction, then that's the number you'd get to.
Thank you. So again, on the legal bills, we've been through this a couple of meetings ago. I think one of the legal bills recently had the second highest figure for Oprah requests, and then the next bill had the highest figure for Oprah requests. It's not substantiated that these are connected to me, and I second Ms. Ansch because every day, almost every day, I get an email from Dr. Lorenz or Miss King of late. I want a legal opinion on this. I want a legal opinion on that. I want a legal opinion. And that raises costs. The Department of Education accountability regulations are consistent with our policy, which says that the superintendent, their designee, or the board president seeks counsel. If you're prepared to prove before the commissioner that these legal bills are directly attributable to me, even though other people review them and I don't even see them, then go ahead and vote for this. I don't think you can prove it. I do not. And I think you don't have a good faith basis for directly attributing those legal bills to me, especially in light of the fact that Ms. Ange said, I am constantly being asked to ask for legal opinions on things because they want to challenge me. And there hasn't been an aha moment. There just hasn't. You heard it tonight. They're trying to say that I wrote that letter without consulting with counsel. I did. The other ones, I think, fall. The public admonishment is not a law. Silencing a board member is not a law. Legal bills, I don't approve. So if the board is prepared to prove this before the commissioner, and I will file a petition for emergent relief, and if you're prepared to defend that and take the consequences in the public for what the students see, that you're going to remove a president based on this, a walk-in motion with no notice that these 4 areas by law require me to be removed. Think about what's going to happen in the future, too. Any board president, anybody could walk in and say, we don't like you. We don't want you to be here when you appoint a new interim superintendent. That's really what it's about. They just don't want me to be here because maybe I am doing such a great job. And as far as chaos, we passed the budget on one meeting. We reappointed every single appointee of faculty and staff that the superintendent requested. We also passed the curriculum on one meeting. There is no chaos. If you look at the last agendas, which I also will present to the commissioner, they're mostly unanimous, whereas last year that wasn't the case. I never brought a motion to remove the president because we had 7-2, 7-2, 7-2. As Ms. Emilo and I were in the minority, but we never challenged the president. We asked our questions. We abided by what the board's decision was. We didn't go to try to remove somebody. And there's been a lot of controversy about presidents over the past couple of years, especially around COVID. I will also be prepared to demonstrate that Mr. Kinney used to release letters on letterhead without consulting with the board. I will be prepared to prove that, but I don't think I need to prove that because I don't think you can meet the arbitrary capricious standard on that one because board counsel assisted me and approved the drafting of that. So if you're very confident that you can prove these other 3 items by law and have the board once again be the subject of a newspaper article by Marcia Stoltz, who just loves clickbait, then go ahead and do it. I don't think it's in the best interest of students to remove me at this level, at this point. It's only a few more months. We're in a delicate time. I want to point out to the public that we are in the middle of negotiations. We just finished, actually, a very successful round with the RHEA, with me helping and mentoring the new board members that were on that committee because I appointed Dr. Lorenz and some other more experienced board members, and all 3 of them quit because they just didn't want to do it, I suppose, or Ms. King gave a newspaper interview saying that we didn't have a lawyer, which is never true. That was false. So a vote against me is a vote for someone else to come in and try to transition the board for the last couple of months of my presidency after I have been dutifully coming to every meeting, attending every single committee meeting, working with the board, getting a new council appointed successfully, getting a new interim business administrator appointed successfully. I've never missed a meeting. I don't think I've ever missed a committee meeting. I've been going to the negotiations meeting. I'm sure the chair negotiations can attest to the extensive work every single weekend I have dedicated to this board. So think about what this shows your community during an election season.
Ms. Sullivan, I believe that you've exceeded the 10-minute mark. Can we close discussion
Does
and go to a
anybody else
vote?
have any other comments? Did you want to say anything, Ms. Amelo?
I'd like to say one more thing.
Oh,
if-
sorry.
Oh, I'm sorry.
No, go
Were you
ahead,
going to?
finish, go ahead.
So it just reminded me when you were speaking about negotiations committee, when you appointed Dr. Lorenz and Vivian Uden-King and Mr. DeLate, and then they all stepped down. Now, Mr. DeLate, I understand, had been endorsed by the union, so that would look like a conflict of interest, even though it wasn't. So best to step down. For the other two to just step down with no reason given at the time, then they, in the future, went to the newspaper, to your friend Marcia Stultz, and said it was because you didn't feel comfortable being on the committee with no legal counsel, which we never had no legal counsel at any time. Any time. There was not one day with no legal counsel. So I find it funny for someone to step down and shirk your responsibilities. So we all have a lot more responsibilities to now basically vote out the president because you don't like her and take over. So now you're willing to do all that work, but you couldn't do it before. You shoved it off on everybody else. So I just wanted to point that out. Thank you. Go ahead, Mariana.
Ms. Amelo?
I just want to start by saying that I echo everything that Ms. Anch and Ms. Mariani said in their statements. I can honestly say that I've seen over the last year and a half plus that Ms. Sullivan has dedicated so much of her time to this board and to this district, our community. I believe that it's been above and beyond. You know, this is a volunteer position, and I've seen her in action, and she has always been an advocate for the students, for parents, I think for everyone. And I feel that she's been like very honest and a good person. And I don't feel the same way about the people that are going to vote, you know, yes to this motion tonight. I think that it's despicable. I think that these are opinions and not facts. So you should be prepared to go ahead and back these up with actual facts. I think that the majority of the legal bills are expenses due to OPA requests, that they are from requests, constant requests for legal opinions from board members, numerous ethics complaints against the board from members of the public, and these have all added up. And that is exactly the reason why we have very large legal expenses, unlike ever before. I know that it went through finance. We've talked about OPA requests, and just since Ms. Zeno started in July, we've had over 30 plus OPA requests, and that was at our last Finance and Facilities Committee meeting, so I'm sure that it's much more than that now. So I do not agree with any of these. I think they're opinions. I believe that the chaos on this board that's been constant, because I've been coming to these board meetings for years, the last several years has been Ms. King. I think that she has caused the circus, the crazy, the chaos for the last few years. I think that anyone else who's been coming to these meetings or watching has seen it. Ms. Sullivan wasn't board president last year, nor was she the year before, but Ms. King has attacked publicly basically anyone she doesn't agree with. So she attacked publicly many, many times when Ms. LaForgia was board president and Mr. Budo was vice president. And last year, when she was on the majority, there was chaos last year, and like we were in the minority, and again this year. And I think that this is also a political move. I just hope that people who have been paying careful attention over the last few years and have seen the actions that Ms. King has taken, and that I hope that they know that she's caused the chaos, and she's been the constant. And I pray that this November, that people who go out to vote don't vote for you, because then it's 3 more years of chaos.
So I just have one more thing to say. Campaigning from the dais is not allowed, first of all. Second of all,
I'm not campaigning, I'm not running again.
I'm
so
sorry,
not
I'm
campaigning.
speaking. I'm sorry, I'm speaking. I'll wait till the audience is quiet. The next thing I'd like to say is that last year, under the previous council that we had for over 20 years, the legal bills were, I believe, under $150,000 for the year. I do not believe that this has anything to do with Oprah's, the excessive amount of legal fees. This is not about me. This is not about anyone else on the board. This is about the school district. This is about bringing back sanity to our district. It's not personal.
Audience,
Are you going to do
please.
something about
Audience,
this?
please.
At some point, maybe? Are you going to do something about it? I'm not talking to you. I'm talking to Judith Sullivan. Are you going to do something about this?
Yes, I just asked.
And about Miss Anch talking to me when I'm talking to you?
I'm sorry, I thought she didn't hear you.
She just thought that you hadn't heard me,
Right,
that's all.
okay.
I didn't think she heard.
I'm not done yet, so can you stop talking?
Go ahead, Ms. King, you have the
Well,
floor.
when Miss Anch has control of herself, then I'll continue.
You can go.
So basically, this is not a personal attack. This is not a personal affront. The scare tactics should not be allowed, but you have a right to speak. At the end of the day, this is about the district. This is about the students. This is about the taxpayers. This is about bringing common sense back to the board and allowing the board to do the business of the board. It's all for the students, and that is why it is important for this to happen this evening. I do not agree with the personal attacks that are going on. This is not about me. This is about the motion that is on the table. And if no one else has anything to say, I'd like to ask that we vote, that we close discussion and we vote.
I have one last thing to say. So we received a really lovely letter a few days ago from somebody I don't know, and I won't read the whole thing, but there was a really great list of the accomplishments under my presidency this year. Ensuring committee assignments represented board leadership that is more aligned with the flow community and the clear mandate handed down in the 2022 election. Ensured policies were put into place, they're crediting me and Ms. Anch, to meet the community's desire for more transparency, community involvement, and comfort. This included ensuring 2 meetings a month in a more intimate setting while restoring all public comments to both of the public comment sessions, which was one of the first motions that we made when we assembled as a board. We also passed a new policy that allows board members to teleconference into meetings, and Ms. Koulikortis actually used that policy recently. Ensured non-renewal of the district's previous board attorney, which allowed for new, refreshing legal perspectives that better move the district forward under the complex and ever-changing environment for education in New Jersey, recognizing the community's desire for legal representation, upholding community values with special education, parental rights, and conservative local oversight of our school. We hired under our leadership some of the two best law firms in the state. Temporary pause of the district's energy savings improvement investment plan, which was Mr. Bogdansky's motion to ensure the plan pushed through by a previous lame duck board was appropriate and in alignment with the goals of the newly elected board. Ensured that the approval of the budget kept increases to a reasonable level. The budget was actually increased less this year than last year. Oversaw the negotiation of a new contract. I had mentioned that with the district teachers union. Despite the fact that because of the resignations, many of the board members work double and triple duty, like Ms. Anch actually has triple duty, and because they're new, I have a big mentoring load to help them. Oversaw completion of the superintendent's strategic planning process, ensured the mental health of students remained a paramount priority, and I did say at the previous meeting that we had approved really hundreds of thousands. And I did do the research. I went through all the agendas. It's about $3.6 million for student health, wellness, connected to salaries, connected to supports. I go in and sign contracts for vendors to support students all the time for this. And that was just a short list. So I just wanted to read that in my defense before you actually voted. Any other comments at this time?
Ms. Sullivan, is Ms. Wright still on the phone?
Yes. Mm-hmm.
I just have a question. I don't know. For the board to vote on a new president tonight, they can do that tonight, or does there have to be any notice to the public, like a 48-hour notice, or that can just be done tonight? Just curious.
Did you hear the question, Ms. Wright? Uh-oh, did I lose them? So the question was, does there have to be a notice if they replace the president tonight, since it wasn't noticed, I guess is the question.
So since this is a regularly scheduled board meeting, you are permitted to walk in resolutions. So you're not obligated to provide the 48 hours notice for every single resolution that comes before the board.
Okay. Did that answer your question?
Yep. Thank you.
Any other questions or comments? Okay, so Ms. Demetrio, can you do the roll call on the motion to remove me as president?
Mr. Bogdansky.
No.
Mr. DeLate.
Yes.
Ms. Amelo.
No.
Ms. King.
Yes.
Ms. Koulikortis.
Yes.
Dr. Lorenz.
Yes.
Ms. Mariani.
No.
Ms. Anch.
No.
Ms. Sullivan.
No. The motion does not pass. I remain your president. All right. Did you hear that, Ms. Wright and Mr. Disler? I think we can dispense with your call, and thank you so very much for being on the phone. It's 10:40 p.m. Thank you so much. Take care. All right, so where were we? I need a motion for public